Hi everyone, Sharif Attar from ST Law Office, and I'm here with Noelia, who is the translator. She will be translating everything I'm saying into Spanish.
Bueno, hola a todos, buenas tardes. Ella es la abogada Sharifa Tharp, perdón, y yo soy su traductora Noelia. Voy a estar traduciendo todo lo que ella dice.
Okay, great. And today I'm going to cover the topic of coming back to the United States after deportation. That's a popular question that I get. And so I figure it would be very helpful to share some information. But keep in mind that this is about you and your questions.
Bueno, hoy vamos a hablar del tema de volver a los Estados Unidos después de ya haber sido deportado, ¿no? Es una pregunta muy popular que se hace bastante seguido, así que nos pareció muy útil compartir esta información. De todos modos, acuérdense que esto es un espacio por y para ustedes, así que hagan todas las preguntas que sientan necesarias.
Right. So feel free to, even as I'm talking, go ahead and type your questions in the comment box. I'll be keeping tabs on the comment box. And whenever I see your question come in, I will stop what I'm doing and answer your questions.
Entonces, siéntanse libres de preguntar mientras hablamos. Vamos a estar mirando los comentarios, así que hagan todas las preguntas y vamos a frenar lo que estamos hablando para contestarles.
Now, the information I'm going to be providing you today is not going to be personal legal advice. It's going to be general information to help you to decide whether you really need to seek further legal assistance.
Entonces, la información que les vamos a brindar hoy no es información legal, no es ayuda legal personalizada, sino que es información muy general para que ustedes tomen esa información y ahí decidan si necesitan ayuda de un abogado más personalizado.
Right. So if you would like personal legal advice, definitely feel free to call the office at 561-405-4889. Schedule a consultation and we can sit down and really talk about your particular issue.
Bueno, entonces si necesitan ayuda legal más personalizada, siéntanse libres de llamar a la oficina al número 561-405-4889 y ahí vamos a estar atendiendo todas sus consultas.
And be sure to ask your questions in Spanish or English, whichever you're comfortable with.
Y obviamente siéntanse libres de hacer sus preguntas en español o en inglés, en cualquier idioma en el que se sientan cómodos.
Okay, great. So I am going to be talking about coming back to the United States after deportation. Now, no doubt this is a challenging feat, but it is possible. Now, the reason it is challenging is once you have been deported, there is a period of time that you are required to stay out of the United States, depending on the reason or how you were deported.
Bueno, ahora vamos a hablar de volver a los Estados Unidos luego de haber sido deportado. Es algo muy difícil, pero es posible. Una vez que te deportan, hay un periodo de tiempo en el que tenés que estar afuera de los Estados Unidos, dependiendo de tu situación.
So usually the period of time that you're required to stay outside of the United States is 5, 10, 20 years, and even permanently.
Ahora, el tiempo que se requiere que estén afuera de los Estados Unidos puede ser de 5, 10, 20 años o permanentemente.
So once you want to come back, so if you would like to return to the United States before the time that you have to stay out. So for example, if you went through expedited removal because of an issue of misrepresentation or fraud while you are coming in, then you would have to submit a special type of application.
Bueno, ahora, si te gustaría volver a los Estados Unidos antes de ese tiempo, que tenés que estar afuera, por ejemplo, si te tuvieron que sacar aceleradamente porque tuviste mala representación, esto, bueno, depende de cada caso.
Okay, and we have a question here, and actually, this is an example that I can use, and it is an individual. So this case is a case where an individual was removed because of a crime, and because of that they would like to return. So they have a family, they have this person has a spouse, this person has children in the United States, and you can go ahead and translate.
Ok, bueno, nos entró una pregunta y es sobre un caso específico que nos va a ayudar para explicar justamente lo que estamos explicando. En este caso, es una persona donde lo sacaron por haber cometido un crimen. A esta persona le gustaría volver a los Estados Unidos porque tiene familia, tiene esposa, tiene hijos.
Right. So now the person has remained outside of the United States for more than 15 years.
Bueno, esta persona ha residido fuera de los Estados Unidos por más de 15 años ya.
Right. And so now what would happen is, first we have to look at, and this person would like to come back. So first we have to look at the period of time that they've already been outside of the United States.
Bueno, lo primero que habría que hacer es mirar el periodo de tiempo en el que ya estuvo afuera de los Estados Unidos.
So this person has been outside of the United States for 15 years. And the deportation, right? Under the deportation order, he has to remain outside of the United States for 10 years.
Ahora, si esta persona estuvo afuera de los Estados Unidos por 15 años, pero la deportación le exigía quedarse afuera por 10.
So in a case like this, the I-2 is called the special application, the I-212, permission to reapply for reentry would not be necessary because the time period that they were supposed to stay outside of the United States has passed.
Bueno, en un caso así, la aplicación especial I-212, que es un permiso para reaplicar para volver a entrar a los Estados Unidos, en este caso no sería necesario porque esta persona, el tiempo que tenía que pasar afuera de los Estados Unidos, ya lo pasó, ya estuvo afuera.
Now, keep in mind, once again, it really depends on how long, what the crime was. So I didn't talk about that. But there are certain criminal offenses that require the person, so in addition to, so they require them to be outside of the country permanently, bars them from the United States permanently. In this case, the first example I gave you, they just had to stay out for 10 years. However, there are more serious offenses that are, impose permanent bars. In a case like that, the I-212, permission to reapply for reentry, would be required, no matter how much time has passed.
Bueno, ahora tengan en mente que esto depende mucho de cuál fue el crimen, ¿no? Hay ciertas ofensas criminales que requieren que la persona se quede fuera de los Estados Unidos permanentemente. En este caso, el primer ejemplo solamente eran 10 años, pero hay crímenes más serios en donde te sacan permanentemente. Y en estos casos sí es necesario la aplicación I-212.
So, and I want to change up the example a little bit to address Orlando's question. And Orlando says 8 years. He's been outside of the United States for 8 years. And it once again, it depends on the type of criminal offense. Certain types of offenses that are called criminal, so they are considered aggravated felonies. They have a permanent bar. Usually, that could include assault as one of the aggravated felonies under immigration law. Now, that means that there is a permanent bar, and that means that the permission to reapply for reentry will always be required.
Bueno, ahora queremos cambiar el tema para contestar específicamente la pregunta de Orlando. Él dice que ha estado afuera 8 años. Obvio que esto depende de la ofensa criminal. Algunas se consideran crímenes agravados y se expulsan permanentemente por estos. Estos crímenes pueden incluir, por ejemplo, asalto. Si hiciste uno de estos crímenes y te sacaron permanentemente, ahí el permiso para reaplicar va a ser necesario.
Now, this is where it gets complicated. The type of criminal offense and whether it qualifies as a aggravated felony, or whether whether the underlying crime will exactly whether it's going to have a permanent bar really depends on the facts, because there are two ways that criminal offenses can cause inadmissibility. And I'm going to allow Noelia to translate, and then I will explain.
Bueno, ahora acá es donde se complica. El tipo de delito criminal y si califica como delito agravado o si tendrá expulsación permanente depende verdaderamente de los hechos. Y hay dos maneras en que esto puede causar una inadmisibilidad.
So, in the case of a criminal offense can render an individual inadmissible, meaning that they cannot come to the United States if they were convicted for 2 or more offenses that had a total of 5 years or more sentence.
Bueno, ahora, el caso de un delito criminal que te califique como inadmisible para los Estados Unidos es si fuiste acusado de 2 o más ofensas que en total tengan un tiempo de carcelación de 5 años o más.
And then the other is if an individual committed an aggravated felony, which under the law, there is a specific statute that has a list of types of criminal offenses that qualify as aggravated felonies, and those have a permanent bar. So it would really require me to evaluate the particular criminal offense to determine whether it falls under an aggravated felony.
Bueno, ahora si un individuo cometió un delito agravado y bajo la ley hay un estatuto con una lista de ofensas criminales que califican como estas, como agravadas, y llevarían a la expulsión permanente. Así que en este caso habría que evaluar cada caso personal y cada crimen específico para ver si califica o no.
So, now, in a case where the permission to reapply for reentry into the United States is necessary, and that's once again if you have not stayed outside of the United States for the required period of time.
Ahora, en estos casos es necesario el permiso para reaplicar, para volver a entrar a los Estados Unidos si no has pasado el tiempo que tenías que pasar afuera, ¿no?
There's also so in addition to that, there's also the underlying reason for the deportation.
Bueno, también hay otra razón para la deportación, además de eso, que importa por qué lo deportaron.
So in a case like that, if you are found to be inadmissible for other reasons, then you would have to apply for the permission to reapply for reentry, as well as any kind of applicable waiver that is that's necessary in order to come back into the United States.
Bueno, en un caso como este, si fuiste admisible por otras razones, entonces tendrías que aplicar para el permiso para poder volver a entrar a los Estados Unidos, como también para cualquier renuncia aplicable.
So, in a case like, for example, in the case of criminal offenses, if you are, so we have a question here. I'm going to just pause again. Okay. So, hi there. Thank you for your question. And it's, I have so the immigration denied my first case marriage green card after I took another 18 months extension. Okay. So your green card was denied. So your marriage green card was denied. And you took an 18-month extension. Okay, and so can you provide me the reason it was denied? And what the extension, and what was the extension? Did you attend an interview, or did you request an extension? Can you explain to me a little bit more? I'm just waiting for a minute to see if I get something that comes in. Okay, so I haven't gotten any further clarification. If your green card, okay, so I believe what's happening here is and correct me if I'm wrong on this, but it sounds like you had a conditional 2-year green card, and it was denied the first denied. So when you applied, they gave you an extension on your green card for 18 months. And now that it has been denied, of course, that extension is no longer valid. And in that denial, they would have sent you, sometimes they send a notice to appear in immigration court. So it really depends on why it was denied. I usually handle these. I usually approach this situation in 2 ways. So the first is to look at the reason for the denial, and if it's something that can be corrected before you receive the notice to appear in immigration court, I will go ahead and submit the application and correct whatever needs to be corrected. So, for example, if you submitted your marriage-based your renewal, and it required a waiver because you didn't file with your spouse, but you didn't submit a waiver, so you got a denial letter, and in a case like that, you got the denial letter, but with no notice to appear, then I would go ahead and submit the application along with the waiver. And in a case like that, sometimes there is a chance that the immigration service would review the new application, and it would the result would be different. Now, if you do get a notice to appear, and usually once you get the notice to appear, it's now within the purview of the court. That means that the court will now review your case. They're going to review, so now you're in removal proceedings. However, even though it is an intimidating process, it is a second chance to make a case to the judge, to appeal to the judge, because there is no appeal for this sort of denial. So there's no formal appeal. So once it gets to the court, it's a good time to just go before the judge and with all the evidence to show the judge that this should be approved and that you should continue to get your green card. You should get your 10-year green card. So I hope that was helpful for you. But the way that you approach it really depends on the reason for the denial. I would highly recommend you give my office a call at 561-405-4889, and then I can go ahead and address your particular situation in detail and get you the help you need. So we have another question here, and so I have a question here from Marcia, and is if I think this is if you are hired for work, and please clarify for me if I'm not getting it, but I'm thinking this means, can you go back for work? And now, if you want to return to the United States, and you have an employer who is sponsoring you for a work visa, or even a green card, you will still need to go through the same process that I just explained about applying. So if you've been outside of the United States for less than the period of time that you're supposed to be outside, so once you're deported, you are required to be outside of the United States for 5 years, 10 years, 20 years, or permanently, depending on the underlying reason for the deportation. And if you have been, if you want to come back before the time that you're supposed to be outside of the United States, then you must submit an I-212. And then it depends on why you were deported. If you are, for example, if there's a criminal issue that in addition to the deportation, the criminal issue continues to make you inadmissible, you're going to need a sort of waiver. So if you're coming back for a work visa, and that's chances are it may be a non-immigrant, meaning a temporary work. You're going to come on a temporary work visa. You're going to need a waiver that's called the I-192 waiver, and that's for individuals who are coming back to the United States on non-immigrant visas, but they're also inadmissible. So I hope that was helpful. And you can, drop another question if you need further clarification or if you want to correct anything that I said. Now, Ronald Temple, I was wrongfully deported as an aggravated felon. I filed an habeas corpus, but it was never heard because the filing fee was not paid. Okay, with this, I would definitely want to speak with you. It's going to require detailed analysis because that is a bit more complicated than I can address today, but please go ahead and give my office a call at 561-405-4889 and we can discuss. Now, Orlando, thank you for your first question. And yes, you've sent the information already. However, that is information that I review in detail in a consultation, and I cannot discuss the detailed information here on the show. So once again, schedule a consultation if you would like detailed analysis on your particular facts. And you can give me a call at 561-405-4889. So I think I've answered most of the questions. So just to summarize everything, we just have 2 minutes, and just to summarize everything, when you, depending on how long you've been outside of the United States, you may need to apply for that special application called the permission to reapply for reentry. And that's the only way that you are going to get permission to come back into the United States. You also have to think about the reason, that the underlying reason that you're outside of the United States. So, for example, we talked about the criminal issues. If there is a criminal issue that renders you permanently barred, for example, in Ronald's case with the aggravated felony, if in a case like that, then you're going to always need that permission to reapply. In addition to that, the aggravated felony may not have a waiver. However, there's also always the option to come back into the United States on a non-immigrant visa, and has the that does have a waiver that's available. So in a case where you are coming back on a non-immigrant visa, then you would submit the I-212 with a non-immigrant visa. So Marcia has asked for the number again. So I'm going to post it up, and let me see if I can type it in quickly. Okay, here it is. So call 561-405-4889. And you can go ahead and schedule a consultation, and then I can do a detailed analysis to determine whether you qualify to apply to come back to the United States. Also, I just want to say one other thing before we close out, that while the permission to reapply for reentry does not require you to have a particular qualifying relative, it does, the underlying waiver, which is usually called the I-601 waiver, may require you to have a qualifying relative. So it's very complicated, but it is doable. And so give my office a call so I can evaluate your particular situation to see if you qualify and if something fits. So you can come back, you can be with your family, or you can come here to do what you need to do. Thank you so much for all your questions. I appreciate it. Noelia, thank you for translating for me. And we will be back. You're welcome, Marcia. And we will be back next Friday at 6:30. Thanks so much.